like we're getting ready to rock and roll. Can I have your attention, please? Welcome to the Lowell Planning Board meeting for Monday, October 6, 2008. Tonight we have a light agenda. We have minutes of previous meetings. We have some new business, old business, and then some zoning board of appeals recommendations. Starting off the matter, the first thing on our agenda is the approval of the minutes of the June 5th, 2008 planning board meeting. Any of the board members have any questions, comments, concerns? The only one I noticed is on page 2, halfway down, after it says board decision, the next paragraph, generally board members, then on the end it says member Joe Claremont. Questioned the applicant whether they would be amenable to a deed restriction that would prevent the site from being subdivided at a future date. I think that was Mr. Gendron who made that statement.
That's right, that was
And then
me.
Mr. Claremont indicated later that it was a special permit for the driveway, so he couldn't put the condition on. Is that correct, Steve? Do you remember?
Yes, that's correct.
Okay.
Mr. Chairman, that's a good catch.
Do you remember that, Joe, as well?
Yeah, I believe that's correct.
Okay. So if we could amend that just to, Aaron, instead of saying Mr. Claremont, it'll be Mr. Gendron?
No problem.
Okay. Any other board members? Besides that, I have no other comments. Any of the board members have any corrections or comments?
I have none.
Hearing none, I'll entertain a motion to approve the June 5th, 2008 minutes.
So moved.
Moved and
Second.
made in second. All in favor, say aye.
Aye.
Minutes have been adopted. Moving along to June 16th, 2008. I have no corrections or any comments. Any of the board members have any? If not, entertain a motion to approve.
Make a motion to approve the June 16th minutes.
Motion is made in second. All in favor, say aye.
Aye.
Those minutes have been accepted. Thank you. Moving along, we do have a presentation tonight on new business. I'd just like if we could jump over that at this point in time, if no one has an objection, and take up the old business. I believe we'll take a less amount of time. And the board members have no objection. We will move on to old business. 86.1 Bernier Street, special permit extension. The board will review a request by Women in Transition for a 6-month extension for a special permit previously approved by the planning board during the meeting held on March 20th, 2006. The project includes the extension of Bernier Street in order to provide adequate frontage for 3 residential buildings, each containing 2 units for a total of 6 units. The project required site plan approval, definitive subdivision approval, and special permit, all issued by the planning board. May we hear the case for the applicant, please?
Yeah, Mr. Chairman, members of the board, James Flood, 81 Bridge Street, Lowell, Mass., representing Women in Transition. If you remember, I was in front of you in May requesting, I suppose we can call it an extension because of the various delays we had going through the land court in getting this project approved, and it was our hope that we'd have it closed by now. We are hoping to close it within the next 2 weeks, so the issue has once again come up as to the time frame. And I think really what I want is probably instead of an extension, just something in the record that says it has not lapsed, because I think we made a determination that we were pursuing it before, and that was like we were taking steps under the special permit. So I think really that's what I really would need, something that said that the special permit has not lapsed and we can go forward. Hopefully within 2 weeks. As you can see from the letter, with the time delay, the expenses went up, and they had to go out and get additional funding from the Commonwealth to cover it, which has been obtained. So we're ready to go.
I know in your letter, though, but the bottom line, you asked for 6 months. At this point,
That's what I
okay, all
asked
right.
for, but I think my concern is that it hasn't lapsed, but.
Okay.
But
Go
do you
ahead, Mr.
need, do you
Claremont.
need a certain date that you need to have that through, though? You say it's
Well,
not
I hope we're
lapsed at
gonna
this
close within the
point.
next 2 to 3 weeks, Joe.
Right.
Yeah, so, but I mean, 6 months would be fine if you want to do it that way. That's what my letter stated. That it has not lapsed and extended for another 6 months.
Yeah, I think that would probably make sense this way, you know.
Then we
If
don't
say
have
it's
to come
not
back.
lapsed now, when
Then we
does,
wouldn't have to come
when
back.
does
That's
it
what we
lapse?
get
So,
Extended, so you're safe.
Any of the board members have any further questions? Mr. Gendron?
I was just wondering, is there a date when it lapses?
Yeah, usually they have to come in if they don't act within a certain period of time, and I forget what this one is because it has 3 different matters.
November.
And that's when, like we said, we approved it back in '06, then on May
You
of,
have two years, Steve,
Yeah.
from the date of approval, but I think,
right, and then you come back in May of '08 and you ask for 6
Yeah.
months.
Yeah.
Right,
Right, so that would be next
so
month,
we'd have
November.
more time, but
right.
I think we've been pursuing it, and I think the case law says as long as you're pursuing it, it doesn't lapse. But with the state involved, on my zoning opinion, I have to so state, so.
Uh-huh.
I mean, it's just easier to have it in writing from the planning
Right,
board
from
saying
the
it's
planning board,
effective
something from the planning
instead
board.
of someone trying to interpret the statute
Right.
differently.
But if it could say, extend it for another 6 months, it has not lapsed, if you had both words in there, that'd be good.
And do we have a right to extend
Yes.
special
Yes.
permits like that at our discretion?
Yes.
Yes, especially if the, usually what happens is they could lapse by operation of the time period unless they come in and ask for an extension. So usually when we approve something at the time period, if they don't come in and ask for it, I mean, some people have come in after the time period, then ask that we extend it. Most people, if they're watching the time calendar, will come in ahead of time and ask for an extension. Sometimes, as Mr. Flood said, sometimes they'll already have construction ongoing, and then they'll just say, well, just to make sure, we want to continue it out.
See, I think that the interpretation that Mr. Camacho had was that since we were pursuing, we were acting under it, so we really didn't need an extension, but we asked for it anyway, so. A variance you can only extend for 6 months, a special permit you can go
Yeah,
on
that's
for.
why I said I know the 3Ds were approved, and I forget which one it was, but, yeah. So the special permit was the 2-year?
Yeah,
Right,
2 years.
okay. Anybody else have any questions, any board members? If not, we need to entertain a motion.
I make a motion, Mr. Chairman, that the special permit has not lapsed and that we extend the time frame for a period of 6 months.
I'll second the motion.
Motion made and second, all in favor, say aye.
Aye.
Thank
Do we
you.
want a date certain on that, or just give a 6-month date from tonight?
Just do that, and it's gonna close the next 2 or 3 weeks anyway, so we'll be fine. And if I could have something, Aaron, that I could show them.
Do you need it addressed to your office, or do you need it addressed to the state, or what?
No, if you just do like a decision and file it with the city clerk, I'll get a copy and get it to the state,
Okay.
okay? Thank you.
Thank
Thank
you.
you.
Okay, moving along on the new business. Tonight, we have a presentation for Fair Housing and Zoning Planning Guidance and Tools. The Fair Housing Center of Greater Boston will present the above entitled presentation to the planning board, providing an overview of the implementations of fair housing and the planning tools available to remove them. The Housing Center of Greater Boston is the only private, nonprofit organization solely focused on ending illegal housing discrimination in the Greater Boston area. Now, we hear the case for the applicants, please. If you'd step forward, you can introduce yourself to the board members. I know you've been introduced to myself and Mr. Lockhart already, and we'll let you take over the presentation. Nice meeting you again.
Hi,
This
Joe
is
Claremont.
Joe.
Nice to see you.
Or they can take that mic, I think they're gonna set up over here as well, so you can use that mic, whichever way you want. You wanna, are you gonna control it from the computer or the?
Yeah, and we're taking turns with the presentation, so maybe whichever of us is speaking can stand on the other.
Yeah, they can set up over there. Can you guys see okay, or? All right, I think you can set up over there then, as long as. Yeah, you can use that one, that one. Yeah, just when it's green, it means it'll pick up the voices, but, and what happens is, we're televised, so usually it picks up for people at home. Yeah, because usually we can hear you, but if that's not on at home, they'll just think we're listening to nothing.
I'm told that's the case sometimes.
Well, some people agree.
If I'm here, can all of you see the screen?
Sure. If you want to get back here, I think they can see it a little better, so you, but, yeah. Thank you.
Have a seat and relax.
Sure.
I tend to be more in workshop mode myself, so the presentation, trying to figure out how to manage it.
Oh, thank you.
So most of what you're going to see on the screen is in the packet. We've also added a few extra slides with more statistical and background information for you that we're not going to take the time to go over today, but that you'll have in your packet for later on.
Thank you.
And this presentation is adapted from a roughly 2.5 hour workshop that we do. So we're really looking at giving you all the highlights tonight. We've worked in some specific information related to the region as a whole in Greater Boston, but also in Lowell and the Merrimack Valley and some of the work that we've done up here. But our intent is really, let me go to the next slide, is really to look at the intersection of fair housing, the civil rights laws both for the state and the nation, and the work that the decisions that you all make and the work that you do here. Our organization, as you heard, is a private nonprofit. We've been around for 10 years, celebrating our 10th anniversary this year, and our mission is to eliminate housing discrimination and promote open communities throughout the greater Boston region. We're based in a Boston office, but we serve Norfolk, Suffolk, Essex, Middlesex, and Plymouth counties, and we do this through 6 main program areas. We do case advocacy for people who believe they've experienced discrimination. We'll help investigate, and if we find evidence to support their case, we'll help them file a complaint at the NCAD or to mediate if we can without going to court, or hooking them up with an attorney if that's the best means of action. And we do work closely with CTI here in Lowell and some of the other housing search organizations, training their staff so they know how to refer people if clients are having difficulties. Our testing programs, where we will send 2 individuals out to seek the same house, talk to the same realtor, everything will be controlled in that so that they're the same, except for the one factor we're looking for. So if there's concern that people are being denied because they have children, we'll send one couple who are childless and one couple saying they have kids, see if they get the same information about the housing available. The same can be done for race. The same can be done for other protected classes. We do a lot of education and outreach programs through housing search organizations, through local human rights commissions, others who are interested in making their communities more open and welcoming and giving them the tools to get involved. Trainings like this, we've also done training for the Greater Lowell Landlords Association, the Northeast Association of Realtors, a variety of groups. We've just started doing some work with mortgage brokers so that people understand their obligations under the law. We do policy advocacy work, making sure that the state and, in some cases, local laws are being done in ways that follow what's required for the Federal Fair Housing Act. And then we work with area universities to make sure that we have research that backs up the other programs that we do. All of this is with a staff of 6 and a budget of roughly $600,000, so we're overachievers. In terms of our programming here, we want to make sure that people know what the laws are, and the fact that planning and zoning decisions that you all make in this room affect housing opportunities for people who are currently living in Lowell and people who may want to live in Lowell. There are specific requirements of the law that do apply to the decisions that you make, and often what we find is, especially for volunteer board members doing their civic duty as you all do, people aren't necessarily aware that these laws apply. So that basic awareness is the fundamental piece of what we're looking for. To give you all some questions to be asking, or another way of looking at that is the civil rights glasses or the civil rights lens for making these decisions, and then encourage people to take that action and use that information going forward. So when we look specifically at fair housing, a lot of the confusion out there is people link fair housing and affordable housing as being one and the same. And they are distinct. While there are a lot of affordable housing programs that promote housing opportunities, fair housing is looking specifically at discrimination in the marketplace, and that cuts across income lines. Especially when it comes to race discrimination, in Massachusetts, we still find that race is a stronger determinant of where people live than income does. And we've got some more background information for you on that. The Fair Housing Act prohibits discrimination not only in the rental or sales of housing, but in financing such as mortgages, which we've been hearing a lot about lately, in the advertising of housing available, and in the policy decisions related to housing in a town, which is obviously what's relevant to our work today. In the law, the federal law was passed in 1968, so it's celebrating the 40th anniversary this year, and it specifies that discrimination is prohibited based on these specific categories. Race, color, national origin, religion, and sex have been in the law since the late 60s. In 1988, the law was amended, and it was actually Teddy Kennedy who was the chief Senate sponsor for that, to add familial status and disability discrimination to the federal protected classes. Massachusetts law actually goes back older. It was passed in the 1940s. And not only includes all of the bases of the federal law, but also these additional categories of ancestry, age, marital status, source of income, sexual orientation was added later, veteran status and military status is actually added later as well, and genetic information has been added. Now, that one generally, these are the same laws that prohibit employment discrimination, so some of these are a little less relevant in the housing world, but I think genetic information is one that falls into that category. So basically, any housing decision, whether it's being made by a landlord, whether it's being made by a realtor, whether it's being made by you all, that is having a different impact, either purposefully or not, on one of these groups can be considered a violation of the law. The law also very specifically spells out who's involved. So a property owner making a decision about who they were renting to, landlords doing the same, realtors in terms of doing business, lending and appraising is another area. Neighbors also, there's both in terms of the law itself and in case law. When neighbors have taken action to keep a family out of their neighborhood or harassing a family in their residential development, that they are interfering with somebody's ability to exercise their fair housing rights. And municipal officials and municipal bodies also are specifically regulated under the law. And that is in part explicit in the law. It's also in part a secondary notion of anyone receiving federal funding. There's a specific requirement in the law about your duty to affirmatively further fair housing. And what that means is it's not just that you can't not discriminate, but that because you receive federal funds, not just housing funds, but any federal funds, you have a duty to take a step further to help undo the patterns of segregation and discrimination that have happened in the past, even if you weren't responsible for them. And so that affirmative duty is part of the lens you all need to look at in terms of what impact your decisions might have and where there might be a way of doing it that could actually further, move fair housing along more quickly. Before we move to the demographics piece, and we're going to spend much of the time today looking at the specifics of regulations examples, are there questions that anyone has right now? Okay. Yeah.
You mentioned sources of income as a criteria under the law. I was wondering, does a landlord have the right to decide on a tenant based on, affluence, based on their how much money they make in a year and that sort of thing? Could somebody say, I'd rather rent to this person because they obviously are going to be better equipped to pay the rent?
That's a very good question. If some landlord has to have equal criteria that he's applying or she's applying to everyone to show that they can afford to pay the rent that's being asked of them. What source of income protection particularly covers in Massachusetts is related to the receipt of government assistance. So if somebody has welfare payments or SSI payments, or most common, a Section 8 voucher or another housing voucher, a landlord cannot reject that kind of income just because it's government assistance. So if the money will pay for the rent, then the source of that income shouldn't matter. And the example I tend to use is if you've got a college student with a trust fund or a young mother with a voucher that's going to give you the same amount of money, it's your perceptions of which one might be the better tenant or not. And so that's where those guidelines come in. If you've got equal candidates, all of whom can afford the place, and one of them has a whole lot more money, and you think that's going to give you, especially in this economy, a more stable tenant, then yes, I do believe you have the right to make that decision. Other questions?
Okay. Great. So we're now going to talk a little bit about demographics of the metropolitan Boston area. So this chart basically shows you what's changing in the next 30 years, so from 2000 to 2030, in terms of who's going to be living in the area. So as you can see, the number of people of color are increasing. This chart, this graph, it maps where people are living across the state. And so as you can tell, the different colors show you by the non-white population, the percentage by town across the different areas. So all the white areas means that less than 5% of the people who live in that area are people of color. So in general, the region's non-white population is concentrated into 14 mostly urban municipalities, and more than half of the region's municipalities are more than 95% white. And Lowell is a perfect example of this. If you think about Lowell, a very diverse city, it is surrounded by mostly white suburbs: Chelmsford, Draycote, Tingsboro, Groton, if you're going out even a little bit further, et cetera. So it sort of, it shows again that people of color are mostly living in urban areas, and then if you look at the suburbs, they're predominantly white. So when you think about why is it that people live where they live, there are three areas that come up. Call them the usual suspects. So the first thing, as Ginny mentioned, people always immediately go to affordability. Well, people live where they can afford to live. Makes sense. The next one is, well, discrimination. Where are people allowed to live? Where do they feel welcome? And then the third is choice. Where do people want to live? So we're going to go through each of these three and sort of maybe debunk some myths. Okay, so the first one is affordability, and these three statistics basically show you that looking at home ownership as a measure of where people can live, and that people of color are more likely to live in certain areas, even though they can afford to live across the state. So for example, Latinos are 8 times more likely to buy in Lawrence and Chelsea than affordability would suggest. They can afford to live in other municipalities. They're more likely to buy in Lawrence. African Americans, more likely to buy in Randolph. And overall, in 80% of cities and towns, the number of Black and Latino buyers is less than half what we would expect based on affordability. And this all comes from a study that the Harvard Civil Rights Project and the Fair Housing Center did called More Than Money, which if you go to our website, you can see more information about it if you're interested in the details. If you look at the other end of the spectrum, as opposed to home ownership, which you might consider one end of the economic spectrum, if you look at the, in terms of poverty and affordability, it further shows that where people live is not just based on income. So poor residents of color are twice as likely to live in concentrated areas of poverty, and 3 times more likely to live in severely distressed neighborhoods as poor whites. And this statistic I find particularly striking. Black and Latino households with incomes over $50,000 are more likely to live in poverty neighborhoods than white households with income under $20,000. So poor whites are living in the suburbs. Poor African Americans and Latinos are not. The poor whites are gaining all the privilege and opportunity that might come from living in the suburbs in areas of opportunity that folks of color are not, or may not, depending on where they're living, particularly if they're living in severely distressed neighborhoods. So the next one is discrimination. And through the testing that Ginny described, we have found that African Americans and Latinos experience discrimination in half of their attempts to rent, buy, or finance a home. So half of the time, 50% of the time, when they go out into the marketplace, they're discriminated against, as opposed to their white counterparts. For families with children and people with Section 8, that discrimination happens 2/3 of the time. We did test an audit here in Lowell in 2004, and there's a summary in your folder with more details about the audit if you're interested in reading it. But overall, it showed evidence of discrimination 47% of the time, so about the same as the regional average. Some of the details are different in terms of the percentage of discrimination within the protected classes. Latinos experience the highest incident of discrimination, 63%. As you can see, African Americans, and then Asians the least. And then families with children, again, only 33%. So that's slightly different than the region as a whole, but the overall statistic of 47% is about on par. And I don't know if some of you saw, there was a Department of Justice case just in January that was settled against Pine Properties for discrimination against Cambodian American families. And it was settled for $158,000, 114 of it for the victims and $44,000 as a civil penalty. And that was just in January of 2008. So unfortunately, we know that discrimination is happening.
Sorry. Can you give us an example of what might be considered discrimination? What do you see out there that in
Absolutely.
Lowell specifically?
I'm gonna give you an example in the homeownership realm, and then I'll give you a rental example. So in the homeownership realm, if, for example, we send out testers, and one is a white tester, if I'm sent out, and I go visit a realtor, and the realtor says to me, "You would love this neighborhood, it's a wonderful place to live, let me show you these 5 different houses, I'm gonna," and then she calls me back and follows up and is very solicitous. Let's say an African-American woman is sent. She and I don't know that we're going to the same realtor. The realtor says, "You don't want to live here. Really, you wouldn't be very comfortable here. Instead, I think you should go look over there," which perhaps is a more concentrated area with African-Americans, for example. Potentially the realtor says, "Oh, I only have 2 units to show you that's in your range," even though she showed me 5. And then potentially the realtor doesn't follow up, even though the realtor calls me back. Those are 3 different behaviors that, in comparison, show evidence of discrimination. My experience favors me. I am much more likely to be able to find a home in the neighborhood that I want than the African American counterpart, because I was shown more options, I was followed up with, and I was told that I would feel comfortable here.
In testing specifically in Lowell as well, we did send people that were looking to live in the region. So we would give someone a job in the region, or they were moving to a job in the region, and tested realtors that were large enough that they had holdings both in your suburbs and in the city itself. And we found patterns of steering where the white families were being shown in Dracut and Chelmsford, and the families of color were being shown in Lowell. And that is consistent with what happens in other parts of the state, and that the behaviors in the market are keeping the suburbs white and keeping the cities more diverse. And that's part of, we do these trainings a lot in the for suburban boards as well, in terms of, you all really have some different dynamics, obviously, in a city.
Any other questions about the audit or discrimination or evidence of that? Okay. So the third usual suspect that I mentioned was the preference, the idea that people want to live with folks who are like themselves. And there's certainly some truth to that. However, studies have shown that overall, people are interested in living in integrated communities, and where the difference comes in the percentage of integration. And white people reach their limit around 30%. So 30% integration is good for white folks, whereas people of color are more comfortable with a 50-50 split. At the same time, as you can see, African Americans and Latinos say, when asked, that they would be willing to pioneer in all-white neighborhoods. And what keeps them from doing that is their fear of being discriminated against. So it's not just overt behavior, but it's also perceptions of how they may be welcomed or not welcomed that keeps them from trying to gain access to a certain community or a certain neighborhood. So again, these add as further causes that increase segregation in the region. Any questions?
I actually have a quick question on the survey. The 2004 survey that you did in Lowell, Did that include the suburbs around Lowell, or was that just the city of Lowell that you were doing
No,
that?
it
So
was
that
the
was
region.
That was a
Yeah,
regional
it was the
survey?
Merrimack Valley region.
Okay.
So that's what we did exactly, paired tests. So as Ginny said, we had people who said, oh no, you don't want to live in Lowell, you should go live in
Okay.
Dracut, or vice versa, so that we sent them to both places.
And that included all of Merrimack Valley from Lowell to?
It was Lowell and its immediate suburbs.
Okay, all right.
We were actually originally, the conversation started with, I believe, the person in your position at the time, because the city was considering applying for federal money for fair housing, education and outreach programming. And so we said, let's partner on this and work together, and we can do this assessment for the city. As the Eastern Massachusetts organization, Lowell is the second largest city in our service area, and is obviously a critical city for immigrant populations. So we had a real interest in seeing what the differences were up here compared to the region as a whole, and how that might matter in terms of helping local organizations in here address the issues.
And because of all of the slides that I went through, we care about those regional trends so that we don't just look at cities. We want to see what the behavior looks like with the city and its surrounding communities, and what is helping or not, or helping to either perpetuate or not perpetuate the trends of segregation that we've discussed. So we always sort of look in conjunction.
Other questions? Okay. Well, we've put together this list, and short of a laundry list, but certainly not an exhaustive list, of some of the specific activities in your realm that can have fair housing impacts, or can affect fair housing in your community. So the specifics of the restrictions or regulations that you all put forth, the development agreements that get negotiated with individual developers, requests for reasonable accommodations or variances for people in their properties, issues of condo conversions, issues of occupancy standards of how many people can be living in a house or relatives, redevelopment issues, and inspection and maintenance issues, and marketing the town and the housing opportunities in your city or town, all can have implications. So this is where we really say, you've got all the different regulations and rules that you have to be following. What we're asking is that you learn the fair housing piece and look at it through that lens as well. So in the interest of time, we're just going to talk quickly about 3 or 4 of these. The best rule of thumb that I've been taught in this is looking at planning and zoning decisions as land-based, not people-based. So if you're making the decision about who's going to be allowed to live there in a way that could be restrictive, then that can be problematic if, indeed, it has a different impact for the people on that legal list before. The flip side of that is that you are allowed under the law to use affirmative steps. So affirmative marketing plans or marketing housing opportunities in your city that are based on trying to overcome those patterns of segregation in the past. That's okay. So for instance, back to the Section 8 example, a landlord saying, no Section 8 is a violation of the law in advertising. But saying Section 8 welcome is affirmative marketing to reach out to an underserved population. So it is a funny distinction of saying you can't think about the people if it's restrictive. You can think about the people if it's proactive, but that's the way the law works. And looking at the zoning restrictions and regulations, one of the most common examples we see with this is the battle in the suburbs, especially around family housing versus senior housing or smaller units. Now, the Housing for Older Persons Act does have specific requirements. The Fair Housing Act follows that of saying if you are looking specifically at developing housing for seniors and you do it in this way, you don't have to allow families with children in. But most often, what we're seeing is situations where towns are concerned about more children moving in. They're concerned about the cost of the town. There also, you will hear in the town hearings, whether it's town meeting or a zoning board meeting, of people being really concerned about the obligations of having more kids, or if this is going to be affordable housing, who those people are going to be moving into our towns. Some veiled discriminatory statements, sometimes quite blatant discriminatory statements. And so the planning boards and zoning boards go from what was originally proposed to be multifamily and scale that down either to be an elderly development or to be 1 and 2 bedrooms. So technically it could be families, but it really is geared for singles. Those decisions can be violations of the Fair Housing Act because families with children are protected under the law, and the conscious decision to set up the restriction or the regulation in a way that keeps families out is considered a violation. Now, you see it all the time. And that's part of, quite honestly, what prompted us to start doing this training, is really realizing people are not aware of that obligation and that that's protected under the law. And that can happen in the broader zoning decisions that happen, or it can happen in individual development agreements that are negotiated. The current administration and the requirements coming out from the Department of Housing and Community Development are very clear on what this legal requirement is. I will also say on a soapbox for a moment that there are now 4 studies, the most recent by the Federal Reserve, that show that the number of kids moving into a town and school costs don't correlate. It's the labor costs and the building costs, not the per capita costs, that are causing school costs to skyrocket. Off the soapbox. So that's one place we're just looking at who this is affecting and why.
Can I ask you a question before
Yeah.
you go on? What kind of, so this activity is protected by law. What could the penalty be? Let's say if something came before this board and we came up with criteria that inadvertently, maybe even unknowingly, discriminated against families, for instance.
I'll actually
what could
give
the
you an
penalty be?
example from Western Mass from about 5 years ago. The town of Agawam was approached about building housing for farm workers. It's a rural agricultural area. The farm workers in question were all Latino immigrants, and there was a lot of pushback in the town about not wanting these families living permanently in their town. And on record at town meetings and zoning board hearings was this very race-based conscious decision, and the town denied the permit for the housing. The developer sued and got a $250,000 settlement, I believe, both for the families that themselves that were denied and chose to fight this in a lawsuit, and I believe it was a nonprofit developer that was looking to build the housing itself. So there can be significant penalties. In a larger decision, actually a much, much more egregious example, but there's a town in Ohio that recently had a multi-million-dollar settlement because the way the water and sewer was set up in that town, there was literally the town water supply and a white neighborhood over here with a predominantly black neighborhood in between, and they did, still in 2008, had never hooked up that black neighborhood to town water and sewer. People were still hauling water from wells. And it took, I think it was something disgusting, like a 6-year lawsuit to get that neighborhood hooked up to water. So, I mean, that's the kind of extreme example, but that was just settled over the summer. I mean, that's still going on these days. So it can lead to legal action, and sometimes those settlements are pretty big. Another example of a decision that seems reasonable on its face but can have a different impact is looking at family and occupancy standards. And this particularly comes up in areas where there are a lot of immigrant families, where you do have multiple generations living in a family, or you have cousins, extended family, but that are living together as family, or statistically, Latino and African American families do have more children than white families, at least in our area at this time. So by defining that a family means mom and dad and biological children, and that cousin Joe or grandma or great auntie is not part of the family, can end up affecting immigrant families more. So the decision on its face is trying to make a real decision about who's allowed to live together and control, college student noise in your neighborhoods and all that sort of thing. I lived in Somerville when this was all going on in Somerville. But the impact can be different and have a different impact based on national origin, even if that's not the intent. In looking at redevelopment issues, especially in areas where you are looking at the race of who and national origin of who was living there before, and the income, that's where income mixing can play a role. If you've got a predominantly low-income neighborhood that you're doing a lot of urban redevelopment in, there can be cases made for if you're not allowing for families to remain in that neighborhood through some income mixing and affordability standards, that the racial impact of that can be a violation. And so that's another place where all of the good planning around redevelopment can miss the fair housing lens that ends up having an impact that you weren't intending. And inspection and maintenance issues. This actually comes up, we get calls about this a lot from Lowell, where we have landlords who are dealing with the Lowell Housing Authority Section 8 vouchers and landlords dealing with the CTI vouchers. And because those programs are run somewhat differently, their standards for inspections and maintenance are somewhat different. And so landlords, I was doing a training about a year ago with the Greater Lowell Landlords Association, and they were saying, no, we're fine with one, but we don't want to have to deal with the other. And because of that requirement being a requirement of that program, that's still a source of income discrimination, because they're rejecting one voucher just because of the source of that voucher. Now, that's not something that immediately affects the work that you all do, but in the grand scheme of the city and your housing policy, that is something that's part of how this works together. And it's a situation where regionalism and regional cooperation, like with your towns nearby, could be helpful in terms of helping to address that issue.
Excuse me, can I just ask you a question before we
Yeah.
move on to the next slide? Because defining family, I can tell you, a couple of years ago, we struggled with trying to put together an in-law apartment ordinance in the city, and we weren't successful in doing that. And one of the issues, too, was defining family. And I'm aware of some other communities where that's been an issue. And I don't know if this is something that you'd be prepared to answer, but do you have an example of some of the best practices? Because that's difficult.
Right.
You don't want to create a duplex to family and becomes a rental unit
Right.
when the intent was really to be helpful in
Right.
in a family situation. But
Absolutely. Do we have an example for that? We can get one for you. I don't know off the top of my head, but I know.
if you could, or to get it to Aaron, that would
Sure.
be great.
Yeah. And I think that's also where, working with the regional associations can be helpful at times so that you're not having to recreate the wheel of coming up with things that were problematic.
Yeah, City of Cambridge actually has a good one.
So Aviva's saying the
Yeah.
Cambridge one is actually.
I have a couple of examples of both good and perhaps problematic definitions. I can forward that to you.
That'd be great if you could. Thank you.
So these are two key legal distinctions in the law, and let me say I'm not an attorney. I don't play one on TV. I work with a lot of you all the time, those of you who are attorneys. But in terms of understanding the concept, it's important to look at not just the intent, as I said. If there's no intent of keeping people out, but if the law in its effect disparately impacts one group of people that's protected under the law, that can still be found to be discriminatory under the law. And it also can be found to be discriminatory if the decision as it is not changing anything, but is still perpetuating segregated housing patterns that already exist. That goes back to that affirmatively further obligation that as government officials, as recipients of federal funds, it's not just not to discriminate, but that it's supposed to be using these funds to help undo patterns of segregation. So part of the obligation there is looking more at some of the the materials that Aviva went over very quickly of understanding what the patterns are. And we, as she said, look at things regionally, look at the patterns of center cities surrounded by predominantly white suburbs, and in my mind, that calls for more regional planning and cooperation. But you also can look in terms of within the city. I know Lowell less well than Boston, but I know there are neighborhoods that are more Latino or more Asian or more white or more black, and making plans that end up keeping those patterns in place when, and here's the second bullet, when there was a less discriminatory solution available. So that's where it's, maybe going back to third grade for a moment, but putting your creative thinking caps on and saying, is there another way we could do this? Is there a way we could achieve the same result that we're looking for in our planning or our zoning or this development or this regulation that not only is not going to negatively affect Latinos or Asians in our city, or not negatively affect families with children in our neighborhood, but could actually help promote integration and more housing opportunities that are there. And if you can find, and this gets into the court work, but if there's proof that there was a less discriminatory alternative available that the city didn't take, then that can come back in terms of the liability and when things go to that level. So what we ask is that people really review things with the fair housing lens, or put your civil rights glasses on in terms of making that analysis for the policies that you're putting in place. So patterns of segregation are one piece that you want to be looking at. There are situations that we have seen, and again, we see this more in some of the suburban communities, but putting in excessive requirements for permitting, for extensions on projects that are defined for families or are particularly tied to the Section 8 program. Looking at local preferences. In a town that is 80% or 95% white and is building housing where they're giving local residents first preference, that can be discriminatory. In fact, I believe there was a case against Drake back in the early 90s for their local housing authority preference. Also looking at the income differentials and focusing all of your development funds on home ownership versus rental, or vice versa. Lead paint is a huge piece in terms of keeping families with children out. Is a continual problem. It's not an easy one given the cost of de-leading and the lack of funds to be able to help with that, but it is a priority in terms of making sure that family housing is available. And then issues of language barriers and cultural differences, making sure that the meetings, making sure that the information, the community outreach, the civic engagement process for deciding things is truly open to everyone that is part of the neighborhood to participate. These are just some basic ideas that come up. Each jurisdiction that receives federal CDBG funds, home funds, and others has to do a analysis of impediments to fair housing choice. I know the city has one and actually used it. Our testing evidence is part of that. And these are kind of some of the common suspects, usual suspects that come up in those requirements. In terms of looking at specific examples of discrimination, what you say in this room, in this meeting, and what you say even out of this room, but when you are an official business for the city, matters. And there is case law of statements or comments made by board members, even if it was off the record, but if there was a witness there, it has been used in cases to be able to show that zoning decisions or planning decisions were specifically intended to reduce housing choices for particular groups of people. So remembering that you are a civic leader, that you have responsibilities for what you're saying, and that needs to be part of it. It seems obvious, but again, you'd think we wouldn't have to worry about these things anymore. Knowing the history of your town, knowing the residential patterns, knowing who is there already, even if it's not something that you were responsible for creating in the first place, you do have that obligation of helping to undo those patterns as part of the programming. Obviously, intentionally blocking a development that is designed or will have the effect of bringing in members of a protected class, like the Agawam example. But also situations like requiring extraneous permitting can be seen as creating barriers for people. So for instance, the man who came in here earlier, if you were consistently giving variances or extensions for people, I'm just going to use the standard example, building elderly housing, and yet consistently denying those to people with family housing, there's a pattern of the behaviors that are intended to get in somebody's way. So in wrapping up, we just have some lists, and you've got this list separately in your packet, in terms of the sorts of things that you can and can be doing, looking at the sorts of not only not bad activities that you can undertake, but proactive steps that can help, such as ensuring accessibility standards and zoning housing where it's in opportunity areas that will attract more people. That these are some of the ideas that can help overcome, and are some of the more best practices that we see in cities and towns where these decisions are being made in a way that takes fair housing into consideration. We've also got information in here of other places to look, especially if you're in a hearing where you're getting a lot of NIMBY pushback and people saying, we don't want this, we don't want it here. Not only is the law on your side in your obligation, but there are others in your community that are supportive of promoting integration and promoting housing choice. And so some of these allies are groups like a local human rights commission. Aviva does a lot of training through interfaith groups or through local anti-racism organizations, the committees such as No Place for Hate and such. And they don't always tend to come out to your meetings, but certainly they are folks that can be allies for promoting programming that's out there. So to close up, although we do happen to have, we will have time for questions if you want, but I know people want to get home for the Red Sox. The planning and zoning decisions that you make can have a direct impact on housing opportunity. More often, it can have a disparate impact on those opportunities. And if people protected by the Fair Housing Act are impacted by those decisions, that can be proven to be discrimination. So they are recognizable, they can be avoided, and I hope that in this brief time we've been able to give you some ideas of how to go about that. As an organization, we do provide ongoing technical assistance and information. I know Aviva works with a lot of city and town planners and board members in terms of answering questions when situations come up. So we hope you will use this as a resource as well as just being able to present to you tonight. So. And thank you for the time. Not a lot of organizations have taken this time, as we've said, pushing it more for the suburbs as much as in the cities, but appreciate you all taking the time tonight.
Thank you. I have one question for you, if you don't mind. We see it once in a while, but I know it's starting to be a bigger trend other places. When people come in with a project and it's for over 55 housing, I'm sure you see that a lot more now than you've seen it before. People say, we want them in here. Kids don't have to worry about the kids riding the bikes, going to school, and all the things that you mentioned earlier. Usually when it comes before us, we don't decide, if it's over 55, under 55, we will look at the application and decide it on its merits. Are there any things that we should watch out when something like that comes before us? Something we should be considering when the applicant's saying, then, the neighbors say, well, if they're over 55, I don't have to worry about the kids, other people in my neighborhood and stuff of that nature. I'm sure other communities have seen this quite a bit. We don't see it a real lot in Lowell, but I know it is in other communities.
It is a larger issue in other communities. As you saw, we saw behavior denying families with children was much, much lower in Lowell than it was in the region as a whole. There are specific guidelines in the Fair Housing Act and in the Housing for Older Persons Act, HOPA, that specifically give the guidelines of when something can be considered a 55-plus development. That's something we can also send you the specifics for. But I think if the project is following those guidelines, then that's generally okay. There are times, however, where we see projects saying, oh, this is going to be for seniors, but that's totally marketing and not about the actual structure of the development. And that can be problematic, especially if it's combined with statements either by the developer or by the neighbors that the reason they're doing so is to keep families with children out. That's where you're getting yourself into gray area, pun completely intended, with pushing senior housing over housing for families with children. Because if there's, and we hear from developers who have gone in, both for-profit and nonprofit developers, who've gone in with family proposals, and because of the pressure, neighbor pressure in the local town, have come out with senior only. And there is less of a market for it than people think, especially these days. So yes, that can be problematic, and you could get a suit, the developer themselves could bring a suit for being denied what they thought was a more viable economic project. Families that feel they could have benefited from being in that. There's also a lawsuit from, where was Traffic County? Is that Virginia? There was a lawsuit back in the late 70s from neighbors who found out that a realtor was steering black families out of their town. And they brought a lawsuit saying, we want our kids to grow up in a racially diverse area. And because of the illegal actions of that realtor, we were denied that opportunity. And the courts found in their favor. So even though the family didn't want to pursue a lawsuit, didn't want to deal with all of that, the neighbors actually had a chance to say so. And there have been situations as recently as 2 years ago in Belmont where neighbors did make that argument and ended up, for numerous reasons, not deciding to pursue a lawsuit, but saying that they wanted, that the town, and because of other neighbors in the town wanting to block family housing, that the town was aging and they were missing the opportunity to live in a multi-generational society. So that is where I think you do have, in my opinion, from my seat, you do have the legal obligation to allow family housing if it's being proposed.
That's another example where you want to look at the patterns, sort of the history. What has the town done before? What has the board said before around these sort of developments, so that if there's a historical pattern and consistency, that further builds the case.
Mm-hmm. And that's also where the groups on that last slide of, bringing in members of your school board or your local housing trust fund, or bringing folks like us up to be able to help back you, so that your situation is, look, this is the law, we have to follow the law, but helping to be able to put what, we jokingly call YIMBYs, or yes in my backyard people before you as well. That's an organizing job, which is not your job, but there are people within the municipality wanting to do that work, and they can be your allies in this. But yes, we see that all the time, and it's problematic every time we see it, and I'm hopeful that it will not be too long before there's a clear lawsuit settling that.
Thank you. I mean, I'm sure you're faced with it, because a lot of times what will happen is when parties come before us, we encourage the applicant to meet with the neighborhood. Mm-hmm. And then they'll come in and say, well, we vote with the neighbors, and this is what they want. Mm-hmm. So now what you're telling us is that could be discrimination.
That could be discrimination. And that's also where I think there's a lot more public education needed for folks, number one, realizing that that is problematic, and also dispelling, especially the economic myths about what having families with kids does mean. And you're absolutely right that it is a different situation in a city, and particularly the specifics of Lowell, than it is in any of the neighboring suburbs that we see.
Thank you very much.
You're welcome. Thank you all.
Thank you.
Can I ask one question? I'm curious to know which of the suburbs around us have you made active efforts to speak to the suburbs around us as well?
Yes, I've been doing work in Lowell for the last couple of years and in the surrounding communities. The one that I've been most active in is Chelmsford, actually, and partially through the Interfaith Council there, and working with 3 churches who did a new program of ours called Race and Place. And it's a dialogue series looking at the connection between race and housing opportunities, and then the connection between economic opportunities and all the other things that go along with where you live. And the idea behind that goes to educating citizens about and debunking some of the myths around what race is and what it might mean for their community, and so that you do get people then hopefully who would come before a planning board and folks like yourselves to say, yes, we care about this, we want to live in an integrated community. So it's going back to try to address some of those demographic trends through the civic engagement piece. And that was successful in Chelmsford, and I'm hoping to do more in some of the surrounding communities. We also are doing collaboration with the Lowell Housing Authority, a training for the Lowell Housing Authority on fair housing. And housing authorities have particular additional requirements on them in terms of the affirmative component of their job as it comes to fair housing and deconcentrating poverty. And the Lowell Housing Authority is working to invite neighboring housing authorities as well, Drake, Chelmsford, Tingsboro, I believe. So I'm hoping that staff from those neighboring housing authorities will come as well, which again I see as a way to broaden the conversation out from Lowell to the surrounding communities.
Good. I'm glad to hear that. I think this is interesting and useful information for us. But I also think that in Lowell, you know, of course we have our issues, but one of the things I think we do pretty well is dealing with diversity of all different kinds. And that comes from our origin, I think. So I think it would be good if some of the surrounding suburban communities helped with that effort.
If you have connections to any of the planning boards in the area, I would welcome that. My business card is in each of your folders, and I mean that honestly. If you know folks who are in your position in surrounding communities or any other civic position that you think I should contact, I will do that.
Well, thank you again, we appreciate it.
Thank you.
Thank you very much. Thank you.
It is rather nice. Yeah, way upstairs. Yeah, it's gorgeous.
Moving along back on the agenda, we, under other business, we have notices from abutting towns. I think we only have one or two in the packet. Entertain a motion to place those on file.
Mr. Chairman, I make a motion to place the notices from abutting towns on file.
That is made and seconded. All in favor, say aye. Those matters are filed. We have no A&R plans in our packet this evening, so we'll move right to the zoning board of appeal notices. These are zoning board of appeal notices that will be on for a public hearing on October 16th, 2008, at 6:30 p.m. here in the City Council chambers. These are matters that come before the planning board for recommendation only to the zoning board of appeals. The first matter is a special permit and variance. The application is Paul Vignon, care of Kenneth Constingham, attorney. This is for 71 Lupine Road, which is traditional single-family, to maintain the legal use of a pre-existing two-family according to section 12.1.b within sufficient lot area, frontage, and side yard setback according to section 5.1, and without the required parking according to section 6.1.4 of the zoning ordinance. It appears to be that it's been acting as a two-family for a period of time. There's a narrative in here as part of the application from the attorney's office. So it looks like there's a citation cited by the building inspector dated 3/18/08, and then he brings up the plan and indicates that it's been there for a long period of time, and it's been deeded in not deeded, but it hasn't been deeded, but I think it's been maintained on the books for tax purposes as well as a two-family. And the lawyer gave, I think it's on his memorandum here, he said, currently the city of Lowell assesses the premises as a two-family. It's been continually used since 1951. It was built in '29 and has existed the same dimensions since then. The lawyer's making two arguments. One, it should be grandfathered in, or two, it's not subject to the enforcement of Mass General Laws, Section 7, as it has existed for well over a 10-year period in the statute of limitations by that section. So his argument's twofold on that.
Mr. Chairman, looks like this has been in place for a long time, but in general, I think I get concerned about whether or not this could set a precedent where people could start using a dwelling as a two-family and then come in and say, well, it's already been used for a two-family for some period of time, so let's just grandfather it in. I guess this might be a different situation since it's been held as a two-family for so long and we assess it as a two-family. But still, not sure exactly how we should act on it.
Yeah, I would agree with that, and certainly we don't know the whole story behind it. We have what's in front of us here, but something triggered a criminal violation notice. Don't know what would have triggered that at this point, but it's sort of difficult in this position with just the application recommending approval, so.
Yeah, I think one of the things I'm kind of cautious about is, one, we see a criminal violation notice. Two, then we have the applicant's attorney giving his legal opinion of why it should be allowed. I think whenever we see criminal ordinance, criminal violation, and the attorney's opinion, I think maybe if it was coming before this board, I'd want to refer it to the law department to get some of their input. You know, to see if they concur with the lawyer or not.
Yeah.
And then if they said, yes, that, you know, he is right, it's been this way for so long a period of time, we've accepted it therefore, it is a pre-existing, you have no choice on it, and the statute is told over 10 years and we don't have any limitation. So I'd want to think if it was coming before us for hearing, we'd at least make a recommendation to the law department to see what they would do. So I would think, if I make them a recommendation, I'd almost feel the same way that at this point in time that we'll not take any action due to the fact we'd like to see what the legal rights would be on behalf of the city through the assessors, through the solicitor's office. I mean, when you see a criminal violation and then the lawyer saying it's grandfathered in, or it's in because of Mass General Law, Section 47, without reading that law. So I would think that maybe we could take no action and maybe say if it was coming before our board, we'd ask for a legal opinion, but,
Legal opinion.
and let that stand as it is before the zoning board of appeals. Board members feel comfortable with that?
Yes.
Okay, if that's the case, we'll make that as a recommendation, that for, we'll take no action due to insufficient information here as indicated, and maybe the matter should be referred to the city solicitor's office. Okay. Moving along, the next matter we have is it's a variance for Zen Hun, and this is located at 101 Lakeview Ave. This is to vary the parking requirement for a proposed restaurant according to section 6.1 of the zoning ordinance for off-street parking regulations. This is an unoccupied building. The parking requirement, they need 23 spaces. They have 12, and the applicant stating that he believes most of his business, 80% or so, would be takeout. The only question that jumps into my mind offhand would be, what's the seating capacity for the restaurant? So how many are you gonna have seated, how many are you gonna have taken out? And without knowing those numbers, it's tough to kind of.
It seems like the
Judge.
requirement for a takeout restaurant is lower,
Yeah.
right? That we have lower requirements for a takeout restaurant,
Yeah.
so this probably doesn't fit the description of a takeout restaurant if you're required to have 23 parking spaces.
No, I don't think we have enough information here. I went over there just today to look at that parking lot, and the buildings around there, that particular building is a real eyesore. It would really be nice to redevelop that property into a restaurant like this. I think if this applicant worked with the Department of Planning and Development, they could, and we got some more information on seating, and work with DPD to come up with a design in that parking lot. And maybe, I don't know if you can pick up parking on the street there, but get that to work so we can redevelop the property. It'd be good for the neighborhood. We've got the CVS going down the street there, and this is really run down in there, and I'd like to just investigate this, us to investigate this more and get some more information. I'd make a motion to that effect. Not to take any action this evening, but to get more information regarding the property
Okay, motion's made and,
and the proposal.
anyone want to second that motion? Any comment further?
Yeah, I'll second that motion. Sounds like you're suggesting we take no action, but we recommend that the applicant meet with the Office of Planning and Development and come up with a plan that would work for the redevelopment. because
Exactly, I think it can be done. The parking lot, what they have is a pretty simple parking layout, and I think with a little more sophistication, we could make it all work.
Mhm. So I'll second that.
Okay, motion made and second, all in favor?
Aye.
Aye, chair votes yes. The next matter is for a special permit, and this is Rite Aid, care of Metro Sign and Awning on 11 Wood Street. This is a regional retail district. This is to allow the internally illumination of a signal associated with the pharmacy drive-through from section 6.3.29D of the zoning ordinance. As you recall, we did approve the site plan, and we had a lot of talk about the queuing on the drive-through on the, for the Rite Aid there. So this is for the signage. There is some pictures of the signs in the packet. They don't appear to be too bad. I know a lot of times we have sign designer make a recommendation of these to the Board of Appeals as well. It looks like most of these pictures are more towards the drive-through, I think. At least one of them are.
Mr. Chairman, I would make a motion that we refer this to our chief design planner
Okay.
in charge of signs for a recommendation.
Okay. Motion's made to refer to the design planner before it goes to Board of Appeals.
I'll second the motion.
Motion made and second. All in favor, say aye. Aye. Chair votes yes. The next matter is a special permit and variance. Applicant is Edward Ray, property located at 10 Concord Street, also known as 12 Concord Street, and this is an urban mixed use. And this is to allow a body art establishment, and same within 500 feet of residential zoning district, according to sections 7.3.1 and 7.3.12 of the zoning ordinance. I know on all of our body art matters, they have to get approval from the Board of Health. Now,
Body art,
in our packet, I did see that they had a certificate of Board of Health, but what jumped out on me was the fact that it was permit expired December 31st, '04, and it was on Worthing Street. So I didn't give it much, I didn't give a lot of it.
I didn't see any plot plan here indicating how close it is to the residential zoning district. We're talking 499 feet, or we're talking 3 feet away? So,
Doesn't the book say UMU, you can do that?
What's that? The,
And that urban mixed use?
you can do it, but
And a
there's a
special permit.
requirement that it's got to be outside of 500 feet of the residential zoning
Right, I
district.
missed that.
No body art
Yeah, I would
establishment
think so.
yeah.
within 500 feet of the following districts.
Right. So the question is, how close is it? And then still, if they do put it there, even if they get that special permit, they still have to be approved by the Board of Health. Because when we put the new, a little bit older now, the new zoning in for, we covered, the tattooing and the piercing, we put it all under the body art, and all of it has to be Board of the Health approved as well, to make sure
Yeah.
the establishment is,
Right.
making sure it's health efficient. So, at this point in time, as indicated, we're not too sure how close it is actually to the residential 10 Concord.
We have not enough information.
I would think, if knowing what Concord Street is, it looks up, whether it's the numbers start towards Andover Street and run towards Rogers, which I think they do. Because if, when I'm remembering that is when we allowed the car wash.
Car wash
I think
is
that was like a low number, wasn't it? which is there now, because you look at Concord and Perry, the car wash comes in off Concord. And I think the number there for Perry was a low number, like 10 or 12 as well, so it must
Yeah.
be right around where that new car wash just went in.
Chairman Lynn, actually, it was
Yeah,
14
looks like
Perry
this.
Street, so it's right across the street. Yeah.
Okay.
Yeah.
Yeah, 'cause I remember it was low numbers for the car wash,
Yeah, it's right next door, yeah.
because it used to be Burke Auto.
You know, that should go.
So therefore, we have residential, is right in that neighborhood as well.
Right here,
Yeah, residential's all through Concord Street, Perry Street.
right across the street.
Right.
Yeah, I think there's a good reason for having this ordinance to keep body art establishments out of residential neighborhoods. And I would move that we recommend denial.
I'll second.
Okay, motion's made second, all in favor, say aye.
Aye.
Chair votes yes, recommend denial. Moving along, the next one is request for a sign as well. This is the special permit, and this is by Eastern Bank, and this is at 749 Lakeview Ave, and this is a neighborhood business to resurface in a existing internally illuminated signage for Eastern Bank according with the section of the zoning code. So this is basically, it looks like they're just, they do have a couple of pictures in here to put in the new sign on Eastern Bank. It doesn't appear to be too bad. Whether we want to look at the pictures, make recommendation there, or review it to the sign planner. I like when it says proposed sign, but not to scale, so, I know the whole picture's not to scale, but,
Photo not scale, yeah. The sign
24.
looks like it's 24 inches
yeah, which isn't
yeah,
bad.
on the building. Make a motion, recommend approval.
Motion's made,
I'll second.
and second, all in favor, say aye. Aye, chair votes yes, matter's approved for recommendation. Moving along, the next matter is a special permit and a variance, and this is for sign as well. This is the 603 Bridge Street Realty Trust, and this is on 603 Bridge Street, traditional mixed-use zoning, to reface the sign existing, and to maintain the existing sign for freestanding sign and menu board for Top Donut according to section 6 of the zoning code. So basically, it appears like he's gonna change the Al's Pizzeria sign, the same sides and everything else, to Top Donut. If you look at the pictures, basically, they're the same,
They're identical,
yeah, the same,
both
4 by
in-
6, 4 by 6.
both internally illuminated, so
Yeah.
same deal. I make a motion, recommend approval.
Motion's in favor? All in favor, say aye. Aye. Chair votes yes, that matters for recommendation.
I'm sorry, excuse me, I didn't catch who seconded that one. Was that-
Aaron?
Was it?
What? Good.
Okay, all right.
What?
You seconded that one?
Yeah, this last one, yeah.
I got a question on that. I
Sure.
don't, yeah, I definitely want to see this Top Donut move in there. But I don't think that sign, the top sign is 6 foot by 8 feet. The existing sign over there, the AJ's Pizzeria, is more like 4 foot by 6 foot. I don't know if we want to see a 6 foot by 8 foot sign there. If we approve this, are we gonna put a 6 foot by 8 because it might be too big? I think the dimensions have to be checked here.
So you think the Al's Pizzeria is not 6 by 8? and
Yeah,
that we
the
possibly
existing
might be
sign is
recommending-
not 6 by 8. I
Oh,
can
okay.
tell you it's not.
Or make a motion to recommend approval, provided it's no larger than the existing sign.
Yeah, that's fine. I'll second that.
Okay, motion second, and as amended, approved by all parties? Yes. Okay. Moving along, I believe, that's that last matter. One other thing on the general correspondence, Aaron put in our packet, there's some training issues coming up for, on planning and development and zoning, if anybody's interested in that. You can let Aaron know all the dates are included as well. And I know some of the closest ones here are in Havel, actually, there's some in the mayor's reception room down the hall, put on by, the Middlesex Council of Governments.
Yeah, this time around, we actually have some training courses that are in Lowell. Usually it's Fall River, or,
Yeah.
Yeah, right.
Springfield.
Well, at least
so-
you have one or two right here by NIMCOG.
Yeah, so that's,
Right. So those are right here in Lowell, so if anybody's interested in those, you can check with Aaron there, the dates and times. Moving along, any reports from any of the board members? Hearing none, Aaron, any updates for us to consider?
There's nothing that I have, so.
We have any public hearings for next meeting, 2 weeks from tonight?
No, there isn't. There is possibly, we may have finally a submittal this Friday, or excuse me, next Friday for the November 17th meeting, so maybe we'll start ramping up to some more public hearings, but there's nothing for the 20th.
Okay. Here, no further comments, I'll entertain a
Mr. Chairman?
motion to adjourn.
Mr. Chairman, before you do
Sure.
that, I just thought it was worthy of mentioning that since our last meeting, I believe, we lost a Lowellian, Conrad Gothier, who is a regular visitor down here and a member of the Centerville Neighborhood Group. I thought it would be worthy of us recognize the fact that he will be missed.
Absolutely.
He always had vocal opinions here, but it was always valued, and I know I, for one, will miss his input. I think that probably goes for the board.
At the corner of 6th Street and Bridge Street, the Tedeschi's,
Right.
Yeah.
a little memorial to him in stone. It really looks nice.
Yeah, that's good.
He did a lot of work for Centerville.
You know, maybe we could even reach out to that CVS who's putting a little plaque in the back there
Yep.
that we have allowed, and that was one of the things that he was pushing for. If they could even mention him somewhere. Remember that little space they wanted behind the CVS in the corner of Bridge Street?
Oh, there was a little garden.
Remember that little garden that
Yeah.
he was here
Yeah.
very adamant about, and
Yeah,
CVS
yeah.
said they were?
Paid attention to detail.
He was also pushing hard for more trees in the parking lot up at the
Demoulas.
Demoulas Plaza.
Yeah.
Maybe we
So
can do
maybe, yeah,
something
if
there
we
as
could reach
well.
out to them, and just be mentioned to them, you know, if they, even just a recognition on some way to either one of them. Usually those companies of that nature, if they're doing the garden there and the trees out there, if we mention to them, would you have any problem doing that on my behalf?
No, I have no problem with that. We can certainly look at that. I
Yeah.
mean,
Just say the neighborhood
uh,
activist, you know, the board came to us, and, you know, upon his passing,
Yeah.
and we know how he voted to conserve matters in the area, if they could, you know, the one in the CVS or the one in, out there in the Moolis.
Yeah, I mean, the
You know, if they wanna
Memorial
just
Garden seems to be a
put a little
perfect place
plaque
for it.
somewhere, something like that, and if you want to notify us in return, or notify the neighborhood association, we'd appreciate it.
Yeah, no problem. Absolutely.
Okay. Thank you. Any other comments, board members? Okay, if not, entertain a motion to adjourn.
So moved.
The matters made in second. All in favor, say aye.
Aye.
Good night, everybody. Thank you very much.
Thank you.